argues as a motion in the alternative is to terminate the automatic stay the law provides from the judgment of this court, while the petitioner makes an argument with respect to the court's inherent authority that the stay provisions of 61-11 do not pertain to habeas matters. The court disagrees. The court believes that this habeas case is a civil case and falls within the ambit of the category of cases which are covered by that particular provision of the practice book, and therefore the court believes that those stay provisions do come into play. Petitioner argues, nevertheless, the court has the inherent authority, notwithstanding those stay provisions, to admit Mrs. Skakel to bail. I disagree with respect to the court's inherent authority. I also agree that the law in this area is somewhat uncertain. In Gaines versus Manchin, the Supreme Court did opine that the habeas court had the inherent authority to admit habeas petitioners to bail. But I think you have to look at context, and the context is quite different in Gaines versus Manchin. There you had a group of petitioners who had been convicted, appeals were pending, and who complained to the court in the habeas petition that their public defenders were not paying their appeals and that they were being sort of unconstitutionally deprived of their right to counsel, to have their appeals expeditiously handled. The Supreme Court sent that case back to the trial court for the trial court to fashion a remedy, and in doing so, the court suggested among the various remedies available to the trial court, the court could order the release of those defendants if in fact their counsel were not reasonably reaching their cases, and so there may well be that the habeas court has the inherent authority to order release. I think we all agreed in argument before that if there was a conditions case claiming a constitutional violation in terms of cruel and unusual punishment, that a habeas court might well have the authority to fashion relief, which could include release under certain circumstances. Whatever inherent authority the court may have, it's not unbounded, and I believe it's not applicable to this case. I'm mindful that in 1998 the General Assembly enacted 54-63F of the General Statutes regarding post-conviction bail, and that was a legislative limitation of the court's traditional common law authority with respect to the issue of bail. And that statute provides that one convicted of murder is not entitled to bail pending appeal. Later on, in a case called State versus Cahill, and I'm sure you're all familiar with that case, the court was looking at yet another legislative enactment that was, I think, was in the year 2000, where the General Assembly basically said that anyone convicted of any crime of violence is not entitled to bail, and that was appealed on separation of powers grounds as to whether or not that unreasonably interfered with the orderly judicial process. And the Supreme Court, in looking at that, determined that in fact it was an unconstitutional interference with the orderly functioning of the judiciary. The court sort of mused about that there are people convicted of violent crimes because of the broad definition of violent crimes, which actually could be eligible for probation or outcomes that did not include incarceration. And so the court looked at that anomaly. You have a statute that says you can't get any appeal bond, but bail, so you have to be held in incarceration, where the ultimate sentence might not be incarceration. But importantly, in McCahill, the court opined that the 1998 amendment limiting bail in the way that the General Assembly did in 1998 to preclude post-conviction bail for people convicted of murder was indeed not an unreasonable encroachment and was indeed constitutional. And so that statute's in play. We're talking about the court's inherent authority, and with that statute in play, Mr. Skakel, and with this court's order presently stayed by operation of law, then my order is not in effect. My order right now is not in effect, granting him a new trial and set aside his conviction. So at this moment, he stands before this court convicted of murder, And I think that that statute, therefore, blocks any inherent authority this court may have to grant bail. So I believe the statute trumps inherent authority. I believe that Mr. Skakel cannot be released pursuant to the court's inherent authority. Not so with respect to the practice book provisions concerning the authority of this court to terminate the automatic stay of execution that takes place in every civil case. As you know, 6111, the practice book, deals with this topic and provides that the court who heard the case may terminate the stay after hearing if the court determines that the due administration of justice so requires. As I indicated earlier, and I think you all know, that if I do grant a termination of the stay, that this court's order itself will be stayed by operation of the appellate rules for a period of 10 days to give the respondent commissioner an opportunity to seek appellate review. The question before an appellate tribunal will be whether or not this court abused its discretion lifting the stay. If I deny the motion to lift the stay, then that order, well, would be subject to review on the same basis. The language in 6111, due administration of justice, is not self-defining, but we do have this law that guides our understanding. And I think we heard from both counsel with respect to this during oral argument. In the case of Griffin Hospital Mission at 196 Connecticut, the court indicated that whether the due administration of justice involves requires at least involves an analysis in which the court should consider the likelihood of success on appeal, the irreparability of injury to be suffered if a stay is lifted, the effect of the stay on other parties to the proceeding, the public interest. As to the first criteria, the likelihood of success on appeal, let me first of all acknowledge it's somewhat awkward to ask a judge who's made a decision to then make an assessment of the likelihood of success of an appeal from that decision. As counterintuitive as that may seem, it is what judges do every day. It is in the civil arena provided for, and any time a judge in a civil case makes a decision in which there is an automatic stay and a petition for termination of that stay is made by operation of rule, it must go to that judge. And so that's a situation that we confront now. Assessing it obviously requires integrity as well as activity. In assessing the likelihood of success, I'm impressed that the acts or failures to act by trial counsel bearing on the issue of ineffectiveness were substantial and pervasive. To the court, and fully aware of how rare, and I disagree with Mr. Santos about how regular it is that courts grant habeas petitions based upon ineffective assistance of counsel. It is not a common everyday occurrence, and well, it should not be, because that's the suggestion that it's a common everyday occurrence that trial counsel is ineffective, and that ineffectiveness is prejudicing defendants. But fully aware that it is unusual for a habeas court to grant a habeas. This case was not a close case for this court. I don't think I need to repeat what I said quite clearly, I think, in the very lengthy decision that I issued in this regard. Knowing that this court's factual and credibility determinations will be entitled to deference, and based on my belief that the petitioner had a very strong case, and with the humility of knowing that others will be reviewing my determination in that regard, my sense is this is not a very strong appeal. As to the irreparability of injury to be suffered if the stay is lifted, I don't see harm to the state if it's lifted based upon Mr. Skakel's having waived his right to speedy trial. That's the harm the state claimed in this particular instance, but with the waiver of the speedy trial, the state then is free to make its choices whether to pursue an appeal, which it is absolutely entitled to do, without any risk that its appellate, that the benefit of the appeal will be taken away by one who's insisting on his speedy trial rights. That risk is gone with the waiver of speedy trial throughout the period of an appeal, and so that's the harm that the state claimed it could potentially suffer, and that harm has been removed. As to the third criteria, the effect of the stay on other parties to the proceedings, well, there are not other parties to these proceedings, but there are other parties. And I want to say how sad this is for the family of the victims, that this murder took place in 1975, and here we are in 2013, and proceedings are not yet concluded. Those proceedings are going to go on whether the stay is lifted or not. I just want to reflect that I'm mindful of how difficult this is for the victims of the family, but those cannot control the court's responsibilities in accordance with the law. I also want to say that I don't believe that public interest is a term that's synonymous with popularity. Whether a decision is a popular or unpopular decision doesn't bear on whether the court's decision is in the public's interest. This job clearly is not a popularity contest. I agree with Mr. Santos with respect to the public interest, and that is the public has an interest in knowing that the judicial process takes seriously the provisions of the Constitution guaranteeing to any defendant effective assistance counsel. There is, of course, a public interest in finality, and those interests are reflected in the decision law that's developed about habeas. They're taken into consideration in the law, which instructs the judge to be deferential to reasonable strategic decisions made by trial counsel. There are all presumptions that are in place with respect to the correctness of counsel's conduct. Those are a well-embedded part of our habeas jurisprudence. And in fact, certainly this court took into consideration granting the petitioner a new trial. Once a habeas has been granted, there is a public interest in upholding the law and in justice. The effect of a habeas court in setting aside a defendant's conviction and in ordering a new trial is that the habeas petitioner is put into the same position he was in before trial, that is, of a person accused of a crime awaiting trial. That may be a difficult concept for some to grasp. It's the natural consequence of granting a habeas. It is a natural consequence of the application of the Sixth Amendment. If we look at the flip side of a coin and ask, what's the public interest in keeping incarcerated an individual who's burdened by a constitutionally flawed judgment? It's hard for me to grasp the public interest in doing so. Interest has been incarcerated since 2002. Assuming the state goes forward with this intended appeal, that is certainly entitled to do, and this court denies the motion to lift the stay, then Mr. Skakel would remain incarcerated throughout the appeal process. As history tells us, this is not a relatively short process, and this is not a criticism by this court of the appellate process, but simply a reflection of the reality of how long appeals take. Time between a petitioner's conviction and the issuance of the opinion on his appeal in this case was 3 years and 5 months. He was sentenced in August of 2002. The Supreme Court's decision was issued in January of 2006. The time period between the decision in the petition for the new trial and the Supreme Court's opinion was 2 years and 6 months. In that case, the trial decision was in October of 2007. The Supreme Court opinion was 2.5 years later. Along those lines, I also look to, if I can find it, did you look in my chambers, Nicole? I had, did you look in my chambers? I have I did a little scheme on habeas cases. I might have left it on my desk in there. Would you mind just looking in there? I looked at some habeas cases, and I have a list, and I think I might have left it on my desk inside. Just give me a moment. Let's see if that's there. I became interested in this question of how long appeals generally take, just to sort of try to get a sense. Obviously, each case is case specific. But in addition to looking at how long the Skakel appeals took, I decided to look at habeas cases in general. And what I learned there was in the case of Adams versus Commissioner, which is reported at 309 Connecticut, the judgment of the habeas court was in July of the year 2009. The Supreme Court issued its decision in July of 2013. That's 4 years. In the versus Commissioner, which is reported at 307 Connecticut, the trial court's decision was January 14th, 2008. Supreme Court's decision was October 23rd, 2012. In Michael T. versus Commissioner, the trial court's decision was in April of 2008. The Supreme Court's decision, and that's at 307 Connecticut, was in September of 2012. Gaines versus Commissioner, it was December of 2008 from the trial court, and the Supreme Court's decision was September of 2012. And finally, in Ham, this is the number of cases I looked at, the trial court's decision was in November of 2008. The Supreme Court's opinion was released in June of 2011. The point being that the appellate process, and clearly this is not a criticism of the appellate process, but just a reflection of the reality of how complicated and long it can be and how deliberate that process may be. Not a short process. And so I can't predict how long it might take in this instance, but I do not believe that due administration of justice should require a person whose conviction has been assigned in a strong habeas case to be required to remain incarcerated for the several months or years an unlikely appeal is going to be in place. Accordingly, in balancing the equities in this matter, the court determined that lifting the stay is warranted by the due administration of justice, and the automatic stay of execution is accordingly lifted. Now, the effect of this order is as following. There is, by operation of rule, an automatic stay of my order lifting the stay. I know everybody on this side of the rail gets that, and somewhat complicated, but basically when a trial judge, after a judgment, lifts the automatic stay, that trial judge's action lifting the stay is subject to appellate review upon request of the party who opposed having the stay lifted. And the practice book provides, as you know, counsel, that my order lifting the stay is now on hold for a period of 10 days, during which time the commissioner has the opportunity to seek appellate review of this order lifting the stay. In the reviewing court, my order will be reviewed to determine whether in lifting the stay I have abused the court's discretion. If on review my order is reversed, then the stay remains in effect, with the consequence that my order granting a new trial will not be in effect, and my overturning the conviction will not be in effect, and Mr. Skakel will remain incarcerated, convicted of murder. On the other hand, for reviewing, finds that this order is in accord with the court's reasonable exercise of discretion, then the effect of not reversing this court's order will be that the court's habeas order will be in place, and that is setting aside the conviction, order a new trial. And in that case, the case will be returned to the trial docket. Petitioner will then be eligible for bail, as would any other defendant with similar case pending on that docket. And I don't think anyone disagrees. As a matter of fact, I think everyone has explicitly agreed that under those circumstances, the petitioner would be entitled by statute and constitutional provision to bail, with the terms and conditions to be set by the appropriate court. I do not believe this is the appropriate court to take that action. And that's not a personal comment, it's a jurisprudential comment. That is to say, this is a habeas court. I believe the job of the habeas court is concluded when the court determines the case and anything incidental to that case itself. Having returned the case to the criminal docket, it is only appropriate from a jurisprudential point of view that court determine the terms and conditions of bail, as it would with any other case pending on its docket. While Mr. Skakel will be entitled to bail in his then pending criminal case, the terms and conditions need to be set by the court that has the responsibility for the maintenance of the Part A docket in the Stanford Norwalk Judicial District. statute prohibiting bail for one convicted of a crime will not be in play, because at that point his conviction will have been set aside, and any stay of that order will have been terminated by this court's order. There's also the practical aspect of it, and that is that the GA courts are, not the GA courts, but well, the GA courts and the Part A courts are set up to make bail determinations. I know, Mr. Santos, you somewhat scoff at the notion of a bail commissioner in this case, but that's what courts do. Judges assigned to Part A courts regularly deal with issues of bail in all the cases, serious and not so serious, pending before those judges. And as a practical matter, as well as a jurisprudential matter, that's where this belongs. As to when you can file a motion for bail in that case, it's not my role to be advising you with respect to that, but I would think that during this period of time in which my order has been stayed, that the court would probably not welcome receiving any motions, because there's really nothing pending before that court, and won't be unless this order terminating the automatic stay is not upheld on review. Does the counsel have any questions with respect to the court's order?
No, Your Honor.
I've terminated the stay. My order terminating the stay is by operation of rule stayed for a period of 10 days, during which the commissioner has the right to file a petition for a review of my order. If there's nothing else, court will adjourn for the day.
All rise. Now the Superior Court of Town County is now adjourned.
Okay, Mike, we're almost there. We're almost there, Ben.
It's all of our pens, except Mr. Bennett.
We got 10 days.
Would be coming up.
Yes, but he didn't say exactly what I said, which was they already found that part constitutional. No idea. You know, I don't know, but in all of the ones that I've seen,